Good morning, everyone. Thank you very much for getting up early and coming this morning. I'm sure it's because you love to hear what Tim is talking about and not because you need that extra point before the 31st of March. But regardless whether you need the point or not, what an interesting topic we have this morning. I was just saying to Tim that most of us as lawyers probably think we do know how to negotiate. Although I also said I think I was a hopeless negotiator when I had to do it. And it's like everything, I guess, there are techniques in how to do it properly and to do it better. And it's a daily need for lawyers, barristers or solicitors, and even business people. And so I can see why you'd want to come and want to hear an expert like Tim speak. Tim has been in practice for coming up 40 years. Tim, it's a long time. 20 years as a commercial litigator, and then 20 odd years ago he established McFarlane Legal Dispute Resolution, which is a specialist mediation and conflict resolution practice. He has two other highly experienced mediators with him in John Mott and Michael Tehan. I made a note to myself here. I say Tim is no more, or there will be no more highly regarded mediator in Victoria, with due respect to the barristers in the room and the barristers on our list. There'd be no more experienced mediator in Victoria than Tim. He's conducted in excess of 8,000 mediations, all areas of practice, all jurisdictions. He's obviously an accredited specialist in ADR, and he was in the first group approved by the LIV as an accredited specialist. And he has been listed as one of Australia's leading lawyers in Who's Who mediation, and he's received an LIV Accredited Specialist Achievement Award. You can therefore see why to listen to Tim about the mastering the art of negotiation is a valuable learning experience for all of us, myself included as a barrister's clerk. We at the list, and myself in particular, are extremely grateful to Tim for his generosity in coming along this morning and giving his time to tell us about the mastering the art of negotiation. So please welcome Tim McFarlane.
Thank you, Michael. It's very much for those kind words, and those in this list, sorry, not Michael's list, but the list of attendees, that I feel quite embarrassed and a little humbled, to be honest, to be up here and try and impart some of the experiences that I've had to people in this room. That really, my success and how you gauge success, of course, is always interesting, but the success I do have is, I have to say, is partly driven by, and I have to acknowledge, a number of people in this room, because you're the people I work with, and it's only because you take a particular approach that we can succeed in the sort of roles that we have. I'm not going to, therefore, depending on how this goes, whether I will embarrass people or not, but depending on whether you also want to engage or question or take me to task, and if anyone falls asleep, I'll definitely be calling on them. Michael's already acknowledged the fact that you're all here at such an ungodly hour. I listen to Classic FM in the mornings, partly because I can't stand the drivel when I need my own space and thinking time of the commercial stuff, or even 774, and of course I was a Red Simons fan anyway, and we've all heard a little bit about that. But so this morning there was a piece of Mozart, and I love Mozart, but Mozart, they were playing the cantata, and he was a great coffee addict, and used to inhabit Café Zimmermann in Leipzig, and he actually composed a piece in praise of coffee. Can I say it's the only piece of Mozart I heard that I've really not liked. Then I thought the poor devil probably was drinking International Roast or something along that line, whereas in my case I'd want to play AC/DC or something for the coffee that reflects the way I might be. So what am I going to really try and cover this morning, if that's all right? You'll see the four topics loosely, because I do tend to try and cover a number of issues under each of them. The first is an interesting question in itself. Is it a science or is it a black art? If you think of art in a form, art is something we all say it's in the eye of the beholder. So is it an art form for you as practitioners in the style of approach that you want to take? Or is there some science, psychology to what we do as negotiators? Can I say, obviously, a lot of my experience has come from the mediation ADR world, and that can be a different form of negotiation. And certainly prior to that, in those other years of my practicing career, I did negotiate as a litigator, and of course it was a completely different basis, and I think many of you'd have that same experience. In the middle of all of that, and sometimes this is hidden away for good reason, I was also an investigator and complaints handler at the Law Institute, so I was effectively a policeman for the profession. That won me a lot of friends, I have to say. But I had to also learn the art of negotiation on a different basis. And I don't tell this story very often, but it's relevant for you to understand how one negotiates in difficult positions. There was a gentleman who we'd been trying to prosecute for some time for acting as a solicitor without appropriate accreditations. Some people say there's lots of solicitors that might fall into that category, but this one legitimately didn't have anything. Very successful, or he thought he was. Anyway, called him in for an interview, and one of the rooms upstairs in level 2, where some of you have probably been for mediations, were the interview rooms. I was in there on my own, and this gentleman said, and I kid you not, he said, "Do you really want to do this?" And he had a gun sitting underneath. And I said, "No, look, probably on second thought, so I can deal with this some other form." And called for the chap downstairs, who was one of the last commissionaires we had. His name was John Dorman. I'll always remember it because he was on the door, but his name was Dorman. But he loved this opportunity because he was an ex-Vietnam vet and a warrant officer. Well, did he delight in this removal of this individual. Subsequently, that individual was shot dead in front of a house. And when I contacted the police about it, they said, "Look, we've closed the file." And they didn't really want to know about it. So his death sort of went the way of a lot of these situations. So I had to negotiate myself out of that very quickly, I can assure you. So hopefully none of you will come across that sort of situation. It's something I think we just all learn. Michael's alluded to it. I keep learning every day of the week. Yes, sure, there's plenty of texts on these things, and you can go to all sorts of courses, but at the end of the day, it's life's experiences that ultimately, I think, teach you how to negotiate and how to approach negotiations generally. I'll say some things about how to improve outcomes. The next topic I'm going to blame Luke for. I say in jest, I don't like jargon in this area. I really don't. You'll never hear me talk about win-win and all of those other phrases that people do talk about. I even had someone in a mediation ask me about the use of the white. When are we going to get to the whiteboard? And then when are we going to get to the bottom of the pyramid? And I said, "Look, I'm sorry, that's not my style." BATNA is one of those phrases, BATNA, WATNA, ZOPAs. There's jargon all over the place, but there's elements in that I do want to share with you that I think are certainly important. And then the last one, which is always the fun one, what to do when a party will not move. Now, I did actually tag in, you might have noticed in the heading, science or a question of who is the slickest talker. And some of you, I'm sure, will have encountered something like that as well. My expression for the slickest talker is usually someone that will sell ice to the Eskimos, because they will just talk and talk and talk. This is whilst it's an older quote, but it's actually a very good quote, and one that I think doesn't get much airplay, but it's relevant in this situation. In seeking to settle a matter pursuant to his client's instructions or procedures of the court, the practitioner in some senses gives up his adversary role in favour of a negotiating role. In that cooperative role, it is important that practitioners may be relied upon by the other party and his advisors to act honestly and fairly in seeking a reasonable resolution of the dispute. Now, obviously embedded in that, there were a number of observations I'd make. For my barrister colleagues in this room, and I use that obviously in the royal we, that adversarial role I've seen has been quite challenging for some. One of my best friends, who is a silk, said there's no way he could mediate. He said, "I'm not a good negotiator, I'm a good advocate, and that's what I'm good at." And it is that change that's required. And I was talking to a very good colleague yesterday who mediates and appears and acts as an advocate. And she made the comment, you've got to get the mindset right. Because if you're there in an adversarial role, that will not usually help. And I make a general observation. Of course, there's always roles and there's always times when sometimes it's necessary. But negotiating role is a collective, cooperative role, as it said. Act honestly and fairly, I think that's something we should all do anyway. It doesn't matter whether it's in the form of art of negotiation, but that's really what we should be doing. To give us a bit of structure, I've identified, sorry, here we go, somewhat of a definition, just to help understand where I'm coming from. Negotiation is a process in which two or more people with some ability to influence each other communicate and interact with a view to making a decision on a problem which affects them. It involves the parties promoting their rights and interests and adjusting their positions and views in a common effort to achieve settlement. Now, of course, the thing is the definition is talking about the parties themselves. And we're put in there as practitioners, we're in that mix. And then if it's in an ADR role, then you're dealing with someone like me. So the dynamic shifts and changes. But I think it gives you a good understanding of really what the essence is. As practitioners, I think we all think we can negotiate. And yes, that's probably true up to an extent. But there is some sort of finessing that is necessary. And that's why I think this highlights it well, talks about communication, interacting. It talks about the influence, how you can influence another party, and obviously rights and interests, and that will feed well into the difference in the psychology of it all. Can I say, though, fundamental throughout all of this is that we must be focused on what's in the client's best interests. And that client can be an individual, it can be an institution, it can be a government, it doesn't matter who it is, but we're there to act in accordance with the client's best interests. I often say it's not a day for me to catch up with people in a mediation context. Yeah, sure, it's nice, and that's an added bonus, but the focus always must be on the parties themselves in a negotiation. Sometimes that's forgotten, sadly, and they're left to one side. Occasionally I joke about, I might get lawyers together and have a discussion about issues, and someone suggests a figure and the other says, yeah, that's great, I think that'll do it. And then someone says, oh, we better go and get the client's instructions. It's said lightly, of course, but that's the reality. We can have views, and I've certainly been in situations where the lawyers have a particularly strong view and the client goes against that. And I've said to the lawyers, that's fine. That is the client's wishes. That's their call. As I said, the focus always has to be on what is in the client's best interest. I appreciate that sometimes they actually don't know what's in their best interests, and that's where I think to some extent the role of lawyers is very, very important to help them understand. But you don't end up strongly arming, because the last thing you want is then turn around and say, look, I was pressured and duressed and under duress to sign up. And unfortunately it does happen a bit too. So then what are the vital aspects to consider in improving the outcomes of the negotiation? I'm going to start with the most basic, and I apologise, but it needs to be said time and time again. Preparation. Now, those of you who are barristers in this room will not go to court unless you've obviously prepared and read the brief. Although having said that, I did a mediation with a barrister who I won't name because he's not on your list. But no, I won't.
Absolutely.
Yeah, I will, blow him. And he's a silk, yeah. No, anyway, look, he started in the mediation and did his presentation on behalf of the client. And I stopped him about 2/3 of the way through and I said, sorry, so-and-so, wrong brief. And it was the completely wrong brief. So preparation can be as simple as that. I was going to be a bit wicked and sort of make reference to Michael's previous history in the football area on the basis that preparation that Michael and Francis Burke and the whole group of others would have gone through, but there's so many stories about what was preparation then as against what's preparation now that I don't think that will serve me well. Quite different preparation. Some years ago I was lucky enough to attend a conference overseas where the principal speaker was someone who was involved in the disarmament negotiations in Northern Ireland. That's one of the most fascinating experiences I've ever had. To say the preparation that went into that was probably in the extreme, would be putting it lightly, but for good reason. And it went on for years. And so each case presents its own challenges in that preparation. So what sort of things really am I talking about? And as I said, I know some of this is basic, but you'd be surprised how often, unfortunately, I meet situations where this has not been, these sort of issues have not been addressed. Clearly, obviously, the knowledge of facts and circumstances, I mean, that's the basic. But again, you can be surprised how often little things are missed. I had a situation where there was a credibility issue between two witnesses, and I asked one of the witnesses in private session with the lawyer, did he have any evidence, supporting evidence of a particular set of circumstances? And he said, yes, Tim, I do, in fact, I have a diary. Well, the lawyer nearly collapsed because the lawyer had not asked the questions about what material he might have had to support. He had a diary sitting there. So we had the issue about non-discovery, we had to explain all of that, but the diary was crucial and it changed the whole negotiation. Again, little examples, but they're the ones that can make the difference. Understanding all parties' positions, and I do stress that. Of course, you've got to understand your own client, but as much as you can, and with the benefit of your client's assistance, it's good to try and understand where the other side might be coming from, or the other parties. And obviously that, as I said, that entails effort and work and possibly a little bit of research. But it's important to get as much information as possible. The old adage, knowledge is power, is very important in this area. And it's very important because at different stages you might need to use that knowledge, that power that it delivers, as I said, for your clients, to advance your clients' best interests. I think something that's forgotten, and I'm talking solely about, say, an ADR role at this stage, some clients don't understand what's going on in the process. So it's all very well that we talk about negotiation and what ultimately is going to be the situation, but the clients need to understand what's going to happen. Now, it's very, very interesting, I find, that I'm sure many of you in this room are very, very good at, in fact, if not all, explaining what's going to happen in, as I said, particularly in an ADR context. But you've got to remember, particularly for the individuals, not so much the institutional clients, but the clients are very stressed and their ability to take in information is quite limited. You'd be surprised how often, once we break after a joint session and go into private, into a caucus, how often the number of people might turn to their lawyer and say, can I tell Tim now? They're desperate to tell their story. Now, they haven't either listened beforehand. I've certainly explained process, but they're so stressed they just don't take it in. And again, it's all part of helping them understand what it's all about. As I said at the start, it is not a day out for us to catch up with friends. It is a day very much focused on them as individuals. And as I said, you have to include the institutional and government clients and corporates as well, because at the end of the day, it's all made up by individuals, and each of them will have a particular view, of course. So understanding what's to be engaged and what is going to happen is very, very important. Insofar as in the negotiation phases of any of these processes, one of the questions that is often posed is who should actually be involved when you get to that point. Should it be the lawyers that are doing it? Should it be the clients? Should it be, if there's barristers? Should it be done through a mediator or anyone in sort of a facilitative role? Again, it will depend. It will depend again on the preparation, how parties are feeling about things. In some instances, as some of you know, in a number of the jurisdictions, whilst we have a more formal structure as to any form of ADR process, often parties won't sit in the same room. And that's not just in, say, a partnership dispute or will dispute. It can be involved in so many different areas. And again, that gets back to helping them understand what it's all about. But it's very, very important to also respect that is their wishes at the end of the day. So that's important when it comes to that stage, as I said, the negotiation phase. Having gone through that, but it's important that they must be engaged. Now, I know from a number of colleagues, and I've seen that there is a senior retired judge who is not doing joint sessions at the moment. Now, I don't carry his gravitas or status to suggest that, but there have been times where I don't have a joint session because there might, as I said, the stress levels or party may be damaged, or sexual abuse is a very good example, I'm afraid. And I'm doing a lot of them, sadly, at the moment. And there, of course, there's a completely different dynamic there. Sometimes they want to tell their story but don't want to hear the legal argument or debate. So I would get them involved in telling their story, virtually the impact statement, and then they leave, and then we have the more formal process. Again, it's all directed at ensuring that the parties are engaged and involved in what's going on. And I think if you keep that in mind, you can't go wrong in that element of it, because they feel, I don't use jargon, but they do feel empowered. Some years ago there was a study done by Professor Tanya Sorden, and she did it here in Victoria, and at random chose a number of matters out of Supreme and County Court, and the level of dissatisfaction of the parties tend to be driven by the fact that they felt they weren't engaged in what was going on. So I think that was a very salient point for us all. There's no hard and fast rule as to the style of the negotiation and the phase, as I said, engaging parties, lawyers or mediator. That will chop and change. In fact, there's no hard and fast rule about any of this. And as I said at the start, we can learn every day, and we'll keep learning until the day we retire, like some people. Then we'll learn on a different basis, I suspect. We do. So as I said, there's no hard and fast rule. And the thing is, it may change during the negotiations. You might start on a particular basis. Sometimes getting the parties together in a negotiation can be the last ditch, and we'll talk about that towards the end. I have to say I do like to be involved, but and I will say it because it shows respect that these two gentlemen had, and the seniority that Jeff Scher and Dick Stanley. I was mediating for some years ago, obviously, given Jeff's retired, and it was some years ago, and Dick came up to me and he said, "Tim, would you mind if I spoke to Jeff?" Now, I was, I hadn't had as many years' experience at that stage, but what was fascinating was he respected the process, he respected the role that I had, but felt that if he spoke directly to Jeff, that things would advance, and it did. But I thought, now that taught me a lot, and as I said, he recognised that was an important part of the deal. He'd said it to the clients understood that they were going to speak and seek to negotiate. But he did it, as he said, after asking if I minded, and I said, as if I was going to say to Dick Stanley or Jeff Scher, no, it's got to come through me. But anyway, it did show it was very interesting insight, I thought. The relevant law and impact, of course, that's something we all should know and understand. But having said that, as good as we might be, sometimes we miss something. Sometimes something new pops up that you might not have picked up in the preparation. That creates a very interesting question. And I know the academic writings all talk about, well, do you share it? Do you keep it up your sleeve? Again, I think that reflects, the answer to that question often reflects on the approach that you want to take. But here again, I come back to stressing the approach must be taken upon a basis of what it is that the client wishes to do. If the clients say we're here to settle, and that's a case that's relevant and will help, and the clients are told that, and the clients say, I want to settle, please go and tell the other side about this case, then that's fine. But if the clients want to take a different approach and really are just tyre kicking, then maybe that case won't be disclosed. You've got the age-old problem that people often raise. If I'm aware of it, what do I do with it? You can't say anything because you're not given permission to disclose. It's very difficult. I had a situation some years ago in a personal injuries matter where I turned up and the party for the insurer said, Tim, we've got film and we want you to see it before we start the mediation. For some reason or other, the other side didn't know about it. I don't know why, but anyway. And I said, no, I would prefer not to. I'd like to start and just see how things go. You know, I'm very conscious I don't want to be compromised in the role. And they insisted, and I said, all right. So I saw the footage of this lady who'd been injured. And I'd have to say she could have got a Golden Globe, but anyway. So we started the mediation, and on the basis that I could not disclose. The lawyer for the plaintiff was a very, very dear colleague of mine and very good lawyer, very good solicitor. And he believed his client and went passionately to town in support of her case. And of course, the more he spoke, the worse I felt about it, because I knew full well what the reality was. So again, because I was bound by the confidentiality of what had gone on, I thought, in private session, I just asked one question. And he turned to me, he said, and it just seemed to click, it was that one of those moments in life, and he said, they've got film. I didn't say anything. But as I said, in the end, this lady was virtually tabletop dancing when she supposed to couldn't do anything. But he, whether it was the vibes, that famous phrase from that famous film, but he picked up something, and it was enough to recognise, and the case settled on a walk away for good reason. So let's move on. I'm sorry, I'm sort of conscious of the time, and I'm happy to wait round at the end too, rather than embarrass people if you don't want to ask questions as we're working through. But as I said, there's enough people in this room that I can dob in if I have to, but I won't. Now, this is always the interesting stuff. A friend of mine who is a psychologist thinks I'm a frustrated psychologist, because there is quite an element of psychology to what we do in negotiation. Can I say at the start that no two negotiation will ever be the same? Sure, there'll be similarities, but what I did yesterday will be completely different today. Different set of circumstances, different people, different parties' experiences. But it is interesting to understand at least some of the academic aspects of what we're talking about. So the two fundamental differences in the psychology of it all is the positional negotiating versus the interest base, which is sometimes called in the academic writings the principled negotiation. So what I'll try and do is highlight in short form the characteristics, and you'll probably recognise them as we talk through, and then the advantages and disadvantages. Can I say, and I want you to sort of bear this in mind when we're thinking and looking at some of these issues, that particularly here in Melbourne or Victoria generally, we have quite obviously an increasing multicultural society. I'm seeing that playing out in the work that I do every day of the week, because cultural attitudes and mores, of course, are changing. And that is having a significant bearing. And that's also reflecting cultural backgrounds. Not everyone's, white Anglo-Saxon. And one has to be sympathetic and understand that. And it certainly plays out in quite a different way in the negotiations, I find. And I'm sure that regardless of whether it's, as I said, in ADR processes or directly, you have to be conscious of that. You have to be conscious of, as I said, different social mores, things are changing, and that's one of the things that that's why I say no mediation will ever be the same, no negotiation will ever be the same, because of those fundamental factors that you are dealing with. So I'll just run through the table. I've put up a table that will just sort of help highlight, but there are other elements to that I just want to highlight for you. I just want to start with some of the characteristics and see if you will probably identify some of what I'm talking about, particularly say in relation to the positional style. Tends to be something that a party will take on a basis of an extreme opening position, often quite unrealistic. But it's indicating they're going to take a hard line. They want to focus on their rights. How often have we heard that this is all about justice, I'm going to court because I want my day out, I want to be told? Those sorts of phrases I often say to parties, if I had $1 for every time someone said this is about justice, fairness, equality, all of those other lovely concepts, I wouldn't be there. And the reality is, and I say to people increasingly, if that's what you want, don't go to court. Now, in the early days, some people didn't like me saying that. But can I say, we have to remind people that ultimately, and this obviously is a factor from the alternative outcome of resolution if it's in litigation, the court's made up by humans. Some of us get it right and some of us get it wrong. So it's those sorts of factors that sometimes need to be talked about when they talk about focus on rights, because they won't get that if that's what they want. People that take a positional style tend to be quite aggressive. Becomes a battle of the wills. And as I said, that can create dissension and certainly problems with imbalance between personalities. And certainly in my experience, someone that takes that style is less likely to compromise. They're less likely to deviate off their position. They've got a line, they've got to stick to that line, and very hard to shift them. The flip side is then the interest-based or the principled. And one of the most fundamental aspects of that is, of course, that in that role, you see, in that process, the psychology is you separate the people away from the problem. And then you focus on what their interests are, and not on that position or that right that they maintain. They've got other interests. And the trick is to find what those other interests are. What are the subtexts, the subcurrents that are going on? Now, those of you that negotiate in the probate jurisdiction, and there are a number of you in this room, are well versed in understanding what the subtexts and subcurrents are. And often they're not in the affidavits, even though the affidavits might have gone for 40 pages of complete drivel. And I say that, and I often say, look, the judges won't be interested in how often you fed mum and visited her and those sorts of things. Sounds a little harsh, but that's the reality. But you'll find there is a subtext. Some of the most bizarre subtexts I've struck in that area, I mean, you'd have to be there to believe them, quite frankly, but as I said, those of you that practice in the area will know exactly what I'm talking about. Things like squabble over the ashes, and there's no reference to that in any of the material. And the number of times I've divided up ashes, I'll go he. And that's true. I try to make light of it, but it's always very difficult to say who's getting the top bit and who gets the bottom bit and all that, but it doesn't work. But as I said, subtexts are bizarre and they can come out of left field. And that's something, as I said, that in that principled style, where it's an interest-based, it's obviously something that you need to be alive to. What it does do, though, is it allows a more creative approach, a creative outcome. And that's one of the beauties, I think, of any negotiation, because you're not constrained by the ultimate position of the litigation if that's where parties need to go. You can be as creative as the parties wish to be, and as creative as you can be when you are assisting them. And as I said, that's something I think that needs to be remembered as, and it's clearly one of the benefits, I think, of this particular style of approach. The other thing too is that you'll find that people that are following that tend to be more cooperative, possibly a little easier to work with, and a little bit more pleasant about things. What you will find though sometimes is you can get a mixture of both. Now that's when life becomes really interesting. The best example of it was a case I did some years ago. Again, it was issued out of the Supreme Court, but ultimately it's settled. And I've told this story to a couple of colleagues, and I'll share it with you, partly because the barristers are not in this room, but I'm not going to name them. But it was a landlord and tenant dispute. Supreme Court. You say, oh, how boring. And yes, in one sense it possibly was. The barrister for the landlord, who was the plaintiff, a very good silk, and he did his presentation, very technical. Ultimately, the tenants owed lots of money, and he simply ended up by saying, my client is morally outraged by your conduct. That's what he said, and just left it there. The barrister on the other side for the tenant, who is someone I know is a senior junior, very, very well respected, can often come out swinging, and I thought this is going to be fun. He did his presentation, again very technical about the breaches and things, and then ended up and said to the landlord direct, "Sir, I act for a publicly listed company," which was true. "We're worth 30 million and you're worth 40 million, therefore we can afford to be equally morally outraged." I thought, this is going to be great. And I thought, now is the silk going to respond? But what happened was something I did not anticipate. The landlord himself, who was a very large man, in a very quiet tone simply looked at this barrister and said, "Sir, I'm sorry, you're wrong. I'm not worth 40 million, I'm worth 400 million, and I'll burn 5 and take the lot of you to the High Court." Very quiet, just like that. You can imagine, you could have cut the air with a knife. What was interesting was this man, as I said, had that positional and interest-based flipping around. He arrived in Australia on a ship in the 60s, made cheese sandwiches at a place in Swanston Street, made every cent himself the hard way. And he was all about recognition, understanding, apology. And in the end, I got him an apology that got a discount for the publicly listed company of $800,000 because they said, "We're sorry, we did the wrong thing." So, very interesting exercise. That doesn't happen very often, I have to say, but it's a very good one to explain. Now, so coming back to our little table about the advantages and disadvantages, in the positional style, it can be a very quick. Parties aren't willing to engage. They put a position, it's pretty much, can be very much over. It's, as I said, it's uncomplicated, certainly straightforward. And it does tend to favour a powerful party. Now, as I said, that gentleman I was just talking about certainly was the powerful party, but he was being met by, as I said, a publicly listed company that could fight anyway. But so it changed, again, it changed that dynamic slightly. Because it's quick, it becomes quite inexpensive because things are over very quickly. And as I said, sometimes that's what parties want. The disadvantages, though, is because of that quickness of hardened position, and there's no they're just not inflexible, then it won't work. If there is ongoing relationships, and the academic writings have talked about this for years, and again, sometimes it is a factor that needs to be borne in mind, but it certainly would end a relationship, I think, in a commercial context. It is very much predictable, of course. You can identify someone taking that approach, usually, and you'll know full well what you're dealing with. And if the last bullet point there is what I actually call the just do it syndrome. And by that I mean you get to that point, and if you have an agreement, it's only arrived at often because parties are just sick of the attitude of the other side. And I have people say, "Look, just do it. Just do it." Because they are just tired, they feel browbeaten. And of course, you run the risk that those sort of agreements won't stick too, I think. The flip side, though, insofar as the principled or interest-based negotiation, clearly there's also advantages and disadvantages there. But the one that obviously I think in negotiation, and particularly in an ADR context, is very important, is the flexibility of the approach. It can retain relationships, but I think a lot of the work that I do and others in this room do certainly is not on the basis of an ongoing relationship style of dispute. Certainly the agreements do tend to stick, in my experience, and it does allow that power imbalance. Again, I wasn't going to use jargon, I said, but that power imbalance sometimes has to be recognised and can be quite challenging too. It does, as I say, it certainly takes a little bit more time and can be a bit more involved, but it's actually also the most rewarding, I have to say. You will get clients and parties at the end of the day, having gone through that style of approach, relieved, notwithstanding the relief, they often say, "I hope I never meet you again," which is true. But it is, as I said, it tends to be, and it can be more rewarding for us as colleagues too, I think. And we have to enjoy getting up and coming to work, not necessarily coming to an early CPD session, but coming to work is something we all have to do every day of the week, and we have to enjoy it. Can I say, in talking about preparation, you might want to know a little secret of my own as a mediator. I'll prepare the night before, and the first thing, and my wife will attest to this, the first thing I do is look for the name of the solicitor handling the matter, then the firm, and then I'll go to the end of the pleadings and look for the barrister. And if I know all of those things, I'll tell you how the mediation will run. Now, bear in mind, what's the most fundamental thing I've identified there? Not the parties. Because it possibly will be driven by our colleagues, one of you. And my preparation is to know who I'm dealing with. I have to say I'm blessed that most days I get out of bed and I'm thrilled to be going along to seeing people in this room. Sadly, there are some days I don't get out of bed and thrilled to see some people, but they're not in this room, and they wouldn't be on Green's list either. But it reflects what we have to deal with. I will show my age, but some years ago, after a mediation that I did at Phillips Fox, as it was, up the other end of town, there was a shop in Little Collins Street called Moviola. It sold film posters, and I'd had my eye and wanted to get one in particular. It was a early film Michael Douglas did, called Fallen Down. I don't know whether any of you know it. You can do all sorts of things to find it these days, and you don't have to go to a video shop anymore because they don't exist. But Fallen Down is one of Michael Douglas's early movies, and I bought the poster. I didn't care how much it cost. I wanted it because I'd just come from a mediation where a solicitor and barrister fought, literally. And I better be quick. The solicitor wasn't from Phillips Fox, and the barrister wasn't from Green's list. But they fought. And I took the parties out while they were carrying on and settled out in the corridor. Because the party was just looking, saying, this is bizarre. It was bizarre. And so I settled with them outside and let the other two, and then I stuck my head in when they were still going, and I said, listen, we've settled, we're going. But anyway, why did I want to buy Fallen Down? Michael Douglas was, it's a great poster. It's a great poster. He's standing on a rock with a sawn-off shotgun, white shirt. He was an auditor, obviously, had pens, green and red pens and top shirt. And he just, an average guy, average day, and everything went wrong. And some years ago, I had the pleasure of mediating for the Glen Ira Council, and I tell you this openly because they were sacked after my efforts. Well, nothing to do with me, but and I used to interview them individually in my office, and I had that poster, and I know they were looking at it thinking, what sort of guy am I dealing with here? This is a poster with a guy with a sawn-off shotgun, and he's supposed to be conciliatory in his approach. I tell you that because I'm human like anyone else, and that can play out in many different ways in negotiations, I can assure you. So what then are the attributes that we see from my experience as skilled negotiators? And in saying this, I'm not just talking about those that I've had the fun of working with for 20 years, I'm also including the previous 20 years, as Michael identified. What sort of things do I see that works? Well, obviously the first is the preparedness. And then I do tag in their clients prepared as well. Very important. The presentation of a case, the way it's formulated, the way it's articulated, the clearer, clearly the better. As I said, some of these things are basic, but it doesn't hurt us to be reminded of the basic things that work. The next bit's very important. They've thoughts about the tone they'll use. Is it to be persuasive, not aggressive, matter of fact? Will someone say sorry? Will they take an approach that will create seeds of doubt in the other side? That element is very, very important. And I say that because you need to understand your own strengths and weaknesses. And what do you bring in when you're there acting for a party in the negotiation? Obviously, you've got to try and persuade the other side, and in a mediation context, clearly that's the best opportunity that's presented for the other side to possibly hear the warts and all about their case. That's not necessarily saying the lawyers aren't passing that on, but sometimes parties need to hear it independently and fresh, and hear it better. It's better coming from you. But if you do it in a non-aggressive, matter of fact, look, this is my position. I've had parties on the other side say, look, I understand the barrister or the solicitor, they've got a job to do, they're putting the case. But equally, if the tone's wrong, it arcs everyone. It really does, and it makes the job a lot harder. Will the word sorry be used? Now, the context of that, obviously I referred to the sexual abuse work that I'm doing at the moment, and clearly that is a big issue there. But I say it for a number of reasons, not just in that area as well. In the probate area, in the wills area, you can get family dynamics that have been going on for years, and they're built on a misunderstanding. And all it takes is for someone to say, now I understand why. Now I understand why you've taken that approach, or why you did certain things. And they just go that next step and say, gee, I'm sorry, I didn't, You can tell people many stories about missing the opportunity of saying sorry too. And I think that doesn't hurt for that to occur as well. In commercial context, can I say the best example of sorry that I experienced, and again, this was public, so I will talk about it. Some years ago, there was a lady, a single mum, who'd racked up a lot of parking fines. It was down Frankston Way, and she couldn't afford to pay them. So she presented herself at the police station to serve out her time of the parking fines. The police understood that was fine. They took her into custody, and out of respect for the women in this room, all I'll say is that she underwent the most horrific strip search. And it was awful. Anyway, she got a very good firm to sue the state of Victoria and the police for what had happened. It was an awful case, to be honest, but anyway. What was very interesting about it, though, was I was dealing with the state of Victoria and their representatives. There was an interesting issue, and legally as a lawyer, and you would all appreciate, sometimes these things come along and you do find them interesting and you want to engage in it. And there was a particular position that the Police Association wanted clarified between the role of a police officer and then a jailer. There was two bits of legislation that were in slight conflict. And so the association wanted this determined. I said to the representatives, I said, this is not the case to do that. Why is that? I said, just look at the circumstances. Single mum, parking fines, strip search. No, we need it. So anyway, the case went on. The jury loved her. The jury bolted. The figures just went through the roof. And even on appeal, she sustained she succeeded to a large extent. The interesting thing was the judge ducked the question, so nothing was gained by it at all, and that question's still live. But out of all of that, the woman said to me at the mediation, she said, she could see where it was going, she said, Tim, all I wanted was someone to say sorry, that we shouldn't have done that we went beyond our power and we're really sorry. That's all she wanted, someone to say sorry. State of Victoria, it cost us all a lot of money, and as I said, it didn't deliver the outcome. So it's a powerful word. We've all known the history of it in different areas, both obviously at federal and state, but I think in our little world it still plays a very, very important role and must be borne in mind. A skilled negotiator also, of course, creates seeds of doubt. You don't go swinging in the sense of saying, look, your case stinks. Although I've had some say things along those lines, but it's all about the delivery and creating those seeds of doubt as to the basis of why they take a particular view, whether it's the law, whether the factual matrix is wrong and they just don't understand, whether there's witnesses they haven't fully appreciated the impact of. All that, as I said, a skilled negotiator will utilise as part of the tools of the trade. Some negotiators, of course, use the opportunity to gather information in a non-threatening way. In the early days, and some of you are in this room old enough because you've been working with me for part of that period, to remember how everyone used to say, oh, no, we won't go to mediation because it's a fishing exercise. That's all the other side want to do. They just want to find out things. And so people would clam up. And look, to some extent that was true, but we're far more sophisticated now. And I have said for time and time again, both here and interstate and overseas, that in Victoria we do it better than anyone else. And I stand by that. I think I've got the experience to be able to say that, because we're far more sophisticated. And that sort of silliness about, oh, it's a fishing exercise only, haven't heard that for a long, long time. Because most people are serious in coming along to into a forum to negotiate, to resolve it for their clients, as I said, their clients' best interests. And that's the common thread. Concessions. That's the point of that last bullet point. The value of a concession in negotiation is crucial to highlight and think about. And I say highlight, but then think about, and then the next thing is get client's instructions. If you negotiate, if in negotiations you're prepared to concede something and something early, do it. Because it'll probably take the other side by complete surprise. They don't anticipate it, they don't expect it. And I can tell you of many stories where that's happened. And who's the beneficiary? The client, the party, because the attitude of the other side will change. Because they say, look, they're not mucking around, they can see that there is a problem. Or whatever the issues are. But as I said, you can only do it if you say to your client, I think it will advance things for us if we concede up front. Now, I know in this room there's some people from the LPLC. They take a terrific approach in instructing panel firms if there's liability, we've got a problem. For today's purposes, liability will not be discussed. It's only the quantum. The effect of that, it just sees, the other side will just spin. And so that's a good thing, because it takes out half of the stress. The parties see that and see that as a very positive. And it's for today's purposes, and we understand that. But as I said, I use that as a very practical example of how it can help. The other thing I want you to remember, and it really sort of falls more into the practical pointers a bit, and I've alluded to this in one way or another, we all swim in a small pond. I've talked about honesty and justice and ethics. All of that's particularly relevant in this context, that when you're dealing with people, and you have to remember that you are going to be dealing with them tomorrow and the next day and the next day. And that is something that needs to be borne in mind when you are negotiating. Be upfront, be open, be honest, always act in accordance with your client's best interests, but do it properly. And as I said, the small pond, I was taught that by my principal in Footscray a long, long time ago, and he said, you keep a black book. And he was right. Sometimes it took years for the black book to pop up. I will actually tell you just a very quick funny story about the black book. I'm originally from Geelong. All right, I don't barrack for Geelong, I barrack for Essendon. Let's get that out of that way. My father had an office in opposite the GPO, and there was a milk bar underneath. And I used to go and help my father. It was long before shredders and everything, and we used to tear up all the, not the evidence, but tear up the old documents. And I remember one day, it was particularly hot, went downstairs to buy a can of Coke, and I went for a straw. And the gentleman running the milk bar charged me for the straw. Now, I might have been probably 13. Took me 13, 30, about 30 years later, I met that gentleman in a mediation. Dear, I was torn. I go back to falling down. What do I do? Do I let him have it and just say, that straw, that 2 cents is going to cost you dearly? Anyway, I was tempted, but no, I behaved myself. Because at the end of the day, as I said, I'm human like anyone else. But it's funny how it comes around. Practical pointers. Hasten slowly. Of course it's going to take longer, and you've got to, the other thing is, bear in mind, look after the clients during the negotiations. Whatever it is, doesn't matter whether it's a mediation or where you are, or if you're stuck at the other end of town. remember to engage the clients all the time. Be engaging with them. And it does, excuse me, it does take longer. Of course it takes longer, but hasten slowly is far better. I can't tell you how annoyed I get when after we have a joint session I go into the rooms, the first room, and one party says, well, how much are they offering? And I kid you not, it's in that tone. And I said, I'm sorry, I am not even talking about money at that stage. I need to understand it a little bit more. I need to understand, the people I'm dealing with, or whatever the case is. So it does hasten slightly. There are some times where, of course, if you've got institutionals, or if, say it's a recovery for an insurer, look, it's just about money, you can probably expedite the discussions. But as a general rule, these things take time. Early on, I think it's good if you can establish a sense of collaboration. Not that you're selling your client down the river, nothing like that at all, but just that, hey, we've got to work together. And bear in mind, in negotiations, it's not just two, it can be 5, 10, any number of parties. So it's going to help if you're willing to collaborate with and work with the other lawyers, and then encourage, of course, the clients to do the same. And you can, as I said, you can often, by doing that, identify some common ground that doesn't have to be then addressed. And you can move on to the next phase and as I said, ultimately you'll come down to the sharp end. So the common ground can be addressed, whether it's as simple as confidentiality or whatever it is, but just get some common issues out of the way, and then, as I said, you leave the hard stuff to the end. Attempt to gain control of the process. Now again, that will reflect a little bit of your own style. When I was thinking about this, and when Luke told me, and I have to say I faced up with trepidation knowing how many people were in this room and how experienced and good you guys are at it. And many of you would say, yes, well, I can see how I can control the process, but again, it just reflects, each of you will have your own style. Each of you have got your own personality, and your attempt to control the process, again, is because you're there seeking to engage on behalf of your client. It doesn't have to be an aggressive control of process. You can actually control it by the concessions and by your demeanour in a very nice, soft way. Aggression tends not to work in an effort to control process. And I think that needs to be borne in mind, and I've just realised I'm running out of time. I'll just flip up the next slide, because Luke asked me to do BATNA. Really, look, what we're talking about there is just, again, probably back to the preparation, so that everyone can understand what's the worst outcome, what's the best outcome. Quite often, can I tell you, the parties won't tell you what they really are seeking, and that creates a real challenge. Not only for you, but if it's in the context of ADR for someone like myself, because you've got to try and work with them to understand what they see as their alternatives. And that's something that, as I said, can take some, again, back to the preparation. When I talk about there the attitude to negotiation, they'll have a particular style, a la the landlord. Zopper, again, I apologise, but we all know when we're in a zone. I talk about that. Are people in two different hemispheres, or are they in the zone willing to negotiate? And you'll know what that zone is. And can you achieve agreement otherwise not available? Well, again, that's back to the creativity, I think, of processes that we want to engage. Again, if the client's there to settle, then you'll take the style of approach that's going to deliver that. I think the other thing is, you also, from the perspective, and I'm not pumping for work for the LPLC in saying this, but often I see parties saying to the lawyers in private session, you never told me that. You never said that could be a problem. Pyrrhic victory stuff. That often happens. People will say, you didn't explain that I might not recover because they don't have money. Those sorts of things. Again, it's back to the preparation, but it's again that same issue about what's the alternatives that they're facing. Someone said one of the reasons they wanted to come today was to hear the last bit. And the last bit was what to do when a party will not move. And sadly, we do find that. Interesting though, sometimes it's the party and sometimes it's the lawyer that won't move. And that makes me cross, because it's not the lawyer's position, it's the client. If the client wants to make the call, that's fine. But if a lawyer says, if the lawyer says no, then that's, I think, is wrong. You've got to persist. Persistence is, I think, crucial. Willing to keep going, persevere. I always say, and I apologise because a lot of you have heard me say this, I'm the most unreliable father and husband, now grandfather too, and another one coming, and I've got photos to prove, because I never know when I'll finish, because I will just keep going. Of course, I don't do the Sir Lawrence Street thing, he's retired now, but and better be clear about what I mean by that, and that is lock people up and don't feed them. Anyway, those of you older will remember why I might have said that. But the fact of the matter is, you've got to be willing to engage and persist with the parties, and often you'll find there'll be a breakthrough. Sometimes it is, as I said, adjourn. Break it off, because the parties have probably gone as far as they can. They're exhausted. They can't take any more. You've got to respect age, respect culture, and as I said, sometimes that is required. That's what's required. Change the dynamics. Now, that's something that happens every day, actually. And if your party won't move, sometimes what do? Get the lawyers together. Sometimes I actually get the parties together with me. Sometimes the parties just want to talk themselves without anyone. I had a great case years ago. Both sides were bankrupt. What was funny, one guy lived in a house that had a garage for 8 cars, were full. And I said to the lawyers, there's something wrong here. But I said, what about if we put the parties together? 10 minutes it took, they came out, settled. One of the lawyers made the mistake of going to ask what the terms were. I mean, we're dealing with 2 bankrupts. You don't ask the terms. I said, don't worry about it. And they didn't want to write anything down and left. Anyway, so the other one I'd tell you is from my old Footscray days. I had a particular industry that was well known for cash. And the lawyers couldn't work out what was going on. And it had been the sale of a business, and the cash had disappeared. And I said, give me your clients. There was a particular industry I knew well. And I said, guys, you don't know where I practiced originally, do you? No. I said, Footscray. Oh, did you? I said, do you know half of my clients were in your industry? Oh. I said, I know what's in the boot. That's all I said. And it settled. Because the cash was in the boot. Finally, you're probably all saying, because you've done very, very well. This is a great quote. On the one hand, the negotiator must be fair and truthful. On the other hand, he must mislead. He must mislead his opponent. Like the poker player, a negotiator hopes that his opponent will overestimate the value of his hand. Like the poker player, in a variety of ways, he must facilitate his opponent's inaccurate assessment. The critical difference between those who are successful negotiators and those who are not lies in this capacity both to mislead and not to be misled. Thanks very much.
If we have questions, if I can be heard, if we have questions, there are microphones there in the room, roving microphones.
Or if anyone's embarrassed, I'll hang around and you talk later. Oh, Mr. Swift.
Thanks very much. See you. Thank you. Tim, on this point of when things won't settle, I've noticed a lot more the judges becoming involved in sending things off to mediation at trial or during trial.
Yes.
How is that working? How do you see that working slightly differently to the private mediations?
As in going to the associate judges?
Yes.
Brendan, I can only speak from those that have been sent out to me halfway through, and I suspect is quite different, because you've got the associate justices saying probably more things directed at the trial and where it is. Whereas I've had, in quite a number of them, I've actually done the mediations prior to, and often in that situation the judges haven't. So they're just coming into it fresh. I'll have the history, and that history helps. I think, to be blunt, I think the reality is they're just there to try and go like that. Because they say you're in the middle of the trial, you're going to spend how much more. I don't think they touch the law. They're really just there to really, I think, resolve it in a form and allow the judge to say, well, that's it, done, gone. As I said, whereas in the private ones, and I've had judges refer them out when they know that I've been involved, it's more engaging. Sure, there will be a bit more talk about what the evidence has been and that sort of thing, but it does tend to be a bit more engaging, partly because I've got the history and I know what sort of issues and the buttons to push. Whereas I said, I think that other style is probably more directed at let's get this finished and done and dusted. So not in that pure sense. Anyone else? Yeah, Donna.
Thanks for that, Tim. And I'm sure that you've never had this case with anyone here in the room, but one of the things that I encounter, and I think apologies, even in commercial cases where you'd think it wasn't important, can be the one thing that just gives rise to an opening and a settlement. Very often with dealing with certain, not necessarily clients, but whether it's solicitors or barristers, they're very afraid to allow their clients to apologize because of the alleged admission of liability through an apology. And I often try to get them to understand that that's not the case. Do you have any tips on that? Because the clients won't do it often because they've been advised not to.
That's true, you're right. Often what I've done is actually resolved the core issues, but build into that as part of it, that there will be an apology of form. Sometimes I've actually done the words, sometimes it's put in a form where they then read it to the other room. I structure it so that you try and avoid that sort of roadblock, because it does happen. And that's part of our own training. I think we're always scared of that sort of element of it. But I think if it's explained and they see it as part of the complete package, then that's what works. Anyone else? Yeah, Ferdy.
How do you overcome the perception of some practitioners that a mediation takes a certain course, so they sit and wait for that to happen? It's going to settle at 4:45.
Yes, they'll talk to fill the space syndrome. I think you've got, really, it probably reflects on the engagement by a mediator with the parties and with the practitioners, and really, and you've got to work with them. It's not just running offers. You've got to work and sometimes educate them as to how the process might unfold, and it might be expedited if we take this particular suggested route. Or sometimes what I'm doing to try and expedite is people want to do the dance. I'm saying, listen, that is just not going to work. And one of the tricks I have is to say, look, if you're looking for 6 figures or 7 figures, tell us. Because you get a sense of where people are thinking. And that sort of cuts that sort of syndrome out, I think, quite often. But others need it. And the other thing they need to understand is sometimes the party on the other side takes a lot longer to digest, to process the information. And so they just have to persevere and be prepared to be patient. Again, though, it's part of educating the parties and the lawyers to say, this is how it might play out. As I said, no two approaches is ever the same. Okay. Can I thank you all for your attendance and your engagement. I said most of you stayed awake, so that's a great thing. Enjoy the day, and I hope to see you somewhere around the traps. Thank you very much.